please give us a brief introduction.
So my name is Ritwik Sasmal, and I completed my BA LLB Honors 5 years integrated course from Hidayatullah National Law University, Raipur in 2015. Before that, I had finished my plus 2 from BJP Junior College in the year 2010 and my matriculation from DAV Chandrasekharpur in 2008.
Okay. So tell me why you're interested in this for this post.
Yes, sir. Sir, one of the main requirements of this specific post would be for me to recommend on the constitutionality on various aspects of administrative and legislative action and many legal proposals that may be forthcoming. So for that reason, because of my deep ingrained interest in constitutional law, I have a keen interest in applying my mind to any form of governmental process, which I believe will be an important aspect of the duty in this post.
Okay. So we will concentrate mainly on your some of the land laws, okay, and service code and some other common questions. So, can you tell me land in Odisha under the OLR Act that has been classified under how many classes, and if you can give me examples of one example for each class?
Yes. Sir, there are, according to the interpretation clause, there are 4 classes of land: class 1, class 2, class 3, and class 4. Class 1 land is any land, any form of irrigable land in which 2 or more crops can be grown and have been grown in the past 3 years. Class 2 land is any land in which 1 crop can be grown or has been grown in the last 3 years. Class 3 land is any other irrigable land. Class 4 land, sir, I'm not being able to exactly recall, but I believe orchards come under that category.
Okay. What is the difference between a royal and a tenant, and what are the rights of the royal?
Sir, a royal is a holder of something in the nature of a lease from the ultimate landholder. A royal may not essentially be the person who actually cultivates the land, but a tenant is a person who may come under either the landlord directly or under the royal, and is the person who actually cultivates either personally or through his family members or by employing anyone.
Okay. What are the rights of the royal and the rights of the tenant?
So I'm not being able to recall.
Okay, that is. What are the what is the meaning of alienation of land, and what are the restrictions on the transfer of tribal land?
Yes, sir. So alienation of land means transfer of any form of immovable property. As far as the regulations are concerned, any mortgage or gift or exchange or sale or lease, excluding a testamentary disposition, is prohibited under these regulations for the scheduled tribes. Sir, such regulations prohibit the transfer to any person who is a non-scheduled tribe. However, such a transfer can be made if it is for a mortgage in relation to a loan that has been taken for an agricultural purpose from a public financial institution.
Okay. What do you mean by resumable land?
Sir, so if I may take a minute to
Yes,
recall. Resumable land means any form of land in which, first of all, rights of tenancy have already been given, but such rights revert back to the landlord. So I believe that is the concept of resumable land. I'm not being able to capsulate it clearly, but I believe that's the idea.
Okay. So, what are your hobbies? What you have mentioned in the CIF?
Sir, I play 7 musical instruments.
Mhm.
I compose music of my own. Apart from that, I also play table tennis in my free time, and I also read and write. I love reading modern literature and modern philosophy.
Okay. Uh, Music and your, especially music, you're playing musical instruments. How this hobby is going to help you directly or indirectly in dispensing your duty as assistant director of law?
So the playing of music has been proven scientifically to improve cognitive abilities and to retain the sharpness of cognitive abilities even as we age. So, sir, as I believe that I intend to stay permanently in this service. By the practice of music, I would stay sharp at my work, number one. And secondly, I would also be able to have a greater degree of focus. And as we know that playing of music involves a great interrelation with the memory. So as this job also requires me to memorize many provisions of law, I believe indirectly because of the growth of my memory and the retention capacity, which would not be affected by age, I would be able to also have a decent memory for the job.
Okay, fine. So, suppose the government asks you, okay, to give your legal advice on a particular issue, let's say related to the government is trying to, uh, make the capital city uh, more smarter, since it's a smart city. So they are focusing on infrastructure and all this. And one major problem they're facing is the slums of the city. Okay, so there is a recommendation from another department that slums should be you have to evict and clear the slums, which are basically on government property.
Yes.
Government will use it for some other purpose. So they have asked you to give your legal opinion on this. Okay, so though some of these people are like staying for more than 40, 50 years in those places. Okay, so the draft which has been given by the other department, let's say uh, urban, planning or something, urban development. So they are saying that it is like they have to be evicted and those land have to be used for other activities. Okay, so what will be your advice and why?
Yes, sir. So first of all, the prevention of Odisha Prevention of Encroachment of Land Act 1972 provides for a scenario like this. Sir, for the proposal, I would like to classify this situation into two categories. First is the category of people who have occupied government property for 30 years or more, and a class of people who have occupied the property for 30 years or less. So in case of people who have occupied it for 30 years or less, according to section 7, they can be summarily evicted by the tehsildar, um, and also any construction that they have made over here, which would mean any of the houses that have been built or any other construction that they have been made will be subject to forfeiture. This, sir, however, is subject to the fact that if such person is a landless person or is a homesteadless person, then such land may be settled with the permission of the Tehsildar. In case it's in a municipal area, which is Bhubaneswar, the permission of the subdivisional officer and confirmation by the collector would also be required. So if the property, if the occupation has been for 30 years or more, then according to section 8A of the Act, um, such a situation can be settled in favor of the occupier after transferring the case to the subdivisional officer. So in this situation, notice will have to be given to the department of the government, which is the owner of the who has been allotted that specific property. However, in the case of revenue department, such a notice would not be necessary because it is presumed that they have to be quick in action in any case of encroachment. So these are the two broad classes into which I would divide and suggest my proposal.
Okay. So now coming back to your land laws. So now, in case there is a dispute between the zraet and the tenant, what are the remedies available?
Sir, I'm again not being able to recall the exact provisions, but
No, that section or that is not required. Just the concept you can tell me.
yes, sir.
What happens after that?
Sir, in case of such a dispute, first of all, the civil court's jurisdiction has been ousted, so one cannot approach the civil court. However, the relief for this can be claimed before the revenue officer concerned.
Okay. So, can you tell me specifically what are the rights of the tenant to continue in a resumable land? Resumable land is basically a land which has, as you said, it has been already given to the tenant, but now the owner wants to do personal cultivation there.
Yes.
He wants to cultivate there.
Yes.
So in that case, what are the remedies available to the tenant?
Sir, I believe notice has to be first of all served on the tenant, and so he has to establish that he has been cultivating the land for the last few months or years, and sir, I believe that is the process. I'm again not being able to recollect exactly.
Okay. Now let us come to the CCA Act. So what are the types of penalties which can be imposed by the government on a public servant?
Yes, sir. Sir, according to Rule 13 of the CCA rules, the penalties can be classified into two kinds: major penalties and minor penalties. Clauses 1 to 5 talk about the minor penalties. Minor penalties are imposition of fine, warning, fine, censure, withholding of increments, withholding of promotion, and recovery of any sort of pecuniary loss from the pay given to the government servant, and as well as the penalty of suspension. So major penalties are compulsory retirement, reduction to a lower time scale or a lower service or grade, which is essentially reduction of rank, or removal or dismissal from service.
Okay, it's fine. So is there any exception to the rule that immovable property, land belonging to a tribal, cannot be transferred to a non-tribal? Are there any exceptions to this?
Yes, sir. There are two exceptions. One is mentioned expressly, and the other can be inferred from the definition clause. So the one that is mentioned expressly is in case of any alienation made as a mortgage to a public financial institution to secure an agricultural loan for any agricultural purpose. Number one. So number two, the other exception would be in case of any testamentary disposition made by the tribe.
So, what are the rules related to pension? Okay, suppose due to non-performance or due to some reason, the government has, asked uh, employee to leave or compulsory retirement is being given. So in that, situation, how the pension will be calculated? What pension will be given to him? What is the rule regarding that?
Yes, sir. So compulsory retirement, first of all, has to again be classified into two situations. There may be compulsory retirement imposed as a penalty or compulsory retirement imposed in terms of administrative necessity. So in case it is imposed as a penalty, then Rule 46 of the pension rules say that a compassionate allowance to the extent of two-thirds of the pension that the person would have received will be given to the person. So on the other hand, if the person is removed on the basis of administrative necessity, then Rule 40 of the 40, sir, I think yes, it's 40 or 41. So Rule 41 of the pension rules say that depending on the qualifying service, which would be a minimum of 30 years of qualifying service, or if the person has reached the age of 50 years, depending on how much years he would have qualified for. In that situation, without adding any extra years to his qualifying service, he will be given the normal pension as calculated under Rule 47.
Okay. So, according to your opinion, uh, what changes can be done, okay, in the system, the entire process, okay, so that the representation of women in higher judiciary especially increases? Because now, currently, do you know how many women judges are there in the Supreme Court?
Sir, I believe there are two judges.
Okay. Out of?
Sir, out of 34, it's the full strength now.
So at least if not 50%, then at least one third, okay, judges should be women. Suppose, let us consider in that way. So what are the steps which the government should take to ensure that in higher judiciary?
Yes, sir. Sir, this again hinges on the conflict between the government and the judiciary. Because the judicial appointments are currently decided by the collegium only, this is the reason why the government's hands are tied. If the collegium system was not followed, then the government would be able to bring some sort of a rider and state that it is compulsory for the collegium to suggest at least one third of the judges as being women judges. So unless and until this is done, or if a constitutional amendment has been brought about and the same is not struck down by the Supreme Court, I can see no changes happening in the higher judiciary.
Okay. So, we think that even in the lower judiciary, for example, in Odisha, we are having our government has made the provision for reservation for women. One third of the vacancies are reserved for women under each category.
Yes.
But many states don't have this this particular provision. So, do you think that it is a progressive step, or you feel that no, like uh, reservation should not be there for women, and it should be like open competition?
So no, I certainly agree with the fact that reservation is fully justified. Firstly, because there is a constitutional mandate for the same, generally speaking, in Article 15, Clause 3, which allows the state to make any provisions for the benefit of women and children. So as I had just stated, that in higher judiciary, the same is not possible at all because of the nature of appointments that are made and the collegium that suggests. However, sir, in the subordinate judiciary, because at the end of the day, it is based on open competition. It is perfectly justified for there to be reservations for women, given the fact that women have been an oppressed class for a very long duration of time. And unless such reservations are given, we will not find the voices of women being respected in the enforcement of laws ultimately.
Okay, fine. So, my last question to you would be again a situational question. Okay. Uh, so suppose you are working as assistant director law, and the government basically has a very important project, okay, related to your department, and you are made the you know in charge of that project, let us say, and you are to recruit or suggest two of your juniors, okay, one person among two of your juniors. So one person, he is very honest, okay, but his efficiency, is questionable. Maybe he won't be able to do the work, okay, at least not independently. Other person is very efficient, but again, his honesty, sometimes you doubt that he's, honest or not. So among this, you have to choose one person. So whom will you choose and why? Because it's an important project and government has given the responsibility to you.
So may I ask you if the honesty is related to corruption in terms of money or in terms of
Generally speaking, yeah, a person is, in terms of money also, in terms of other aspects also, you have caught him twice or thrice lying to you. Okay,
yes.
things like that.
Sir, in this sort of a situation, if I am compelled to choose one between the two, then I would choose the person who is honest for the pure and simple reason that it's a public office. And, sir, a public office is first of all accountable to the public. And therefore, when it is in relation to the implementation of an important project which will have far-reaching public consequences, the integrity of the person cannot be sacrificed at the altar of administrative efficiency. So therefore, I believe I would choose the person who is honest, and I would keenly try and supervise him in his performance so as to ensure that he does his level best.
Okay, fine. So that will be the end of the interview. Now, coming to the feedback. So content ଆପଣଙ୍କର ଆଉ presentation ସବୁ ଠିକ ଥିଲା, ଖାଲି ଗୋଟେ ଜିନିଷ ହେଲା ସେ hand movement ଟାକୁ ଟିକେ ଆପଣଙ୍କୁ control କରିବା ପାଇଁ ପଡିବ, ଓକେ, ହାତର movement ଟା ଟିକେ ହଉଥିଲା, ସେଇଟା ହେଲା ଗୋଟେ, but from the presentation and content point of view it is fine. ସେଇ ଗୋଟେ ଜିନିଷ ଟିକେ ଆପଣ ମାଇଣ୍ଡ ରେ ରଖିବେ, ସେଇଟା
Sir, I think OLR ଟିକେ ପଢିବାକୁ ପଡିବ ମତେ, ସେଇଟା ମୁଁ ଇଗ୍ନୋର କରିଦେଇଛି।
ସେ କାଲି ତ ଜଣା ପଡିବ କଣ ସେମାନେ କ୍ୱେଶ୍ଚନ ପଚାରୁଛନ୍ତି, ବଟ୍ ସେମାନେ ଟୋଟାଲି ନ ବି ପଚାରୁନାହାନ୍ତି କିଛି ତା ଉପରେ, ବହୁତ ଜେନେରିକ ଇଣ୍ଟରଭ୍ୟୁ ବି ଗୋଟେ କରିପାରିବେ, କାହିଁକି ନା ଯିଏ ଆପଣଙ୍କର ଯିଏ ଏକ୍ସପର୍ଟ ଆସିବେ ଯିଏ, ଓକେ, ସିଏ ତ ଆପଣଙ୍କୁ ଜେନେରାଲ ଲ ଉପରେ ହିଁ ପଚାରିବେ, ସିଏ ତ ଲୋକାଲ ଲଜ୍ ଉପରେ ଜେନେରାଲି ତାଙ୍କର ଇଏ ନଥିବ। ହଁ, ତେଣୁ ଯଦି ଯେ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଅଫିସର କି ଜଣେ ମେ ବି ସେମାନେ ତା ଉପରେ କିଛି ପଚାରି ପାରନ୍ତି, ଓକେ, ବଟ୍ ଜେନେରାଲ କ୍ୱେଶ୍ଚନ୍ସ ଅଫ ଲ ସେଇଟା ହିଁ ମେନଲି ମୁଁ ଯାହା ଭାବୁଛି ତା ଉପରେ, ଆଉ ଆପଣଙ୍କର କାର୍ଡର ଉପରେ କିଛି ପଚାରିପାରିବେ, ଯେହେତୁ ନୂଆ କାର୍ଡ ରହିଛି ସେଠି ଆମେ ଦେଖିବୁ ତାର composition of service करके से ता ऊपर की चीज़ भी पहुँचा दो, okay, so rest all things are fine.
Sir, how much would you score this?
Score you will get around 36 to 38, okay, out of 50, 36 to 38 around आपको आप 0 interview पे, okay.